Are we ready to go?
We're ready to go.
Okay. So, Dave, who's doing the introduction? Is it me as well?
Yes, sir. I thought it was you, Prof. Adibal.
I wasn't told that, but anyway, just so we won't waste too much time, I've tried to just have a quick look at the series of the speakers. I thought that Dr. Adebola would do it because she knows them a bit better than I, clearly. But so I assume she will do it. But well, good afternoon, everyone. We are here this afternoon to discuss a topic which I'm sure a lot of practitioners are very interested in, because it's a growing area within the sphere of insolvency itself. I would like to thank the NBA-SBL for doing what they have been doing over the years and even more recently. That's bringing us topics that are close to the practice itself. And the topic we're dealing with today is company voluntary arrangements. It's something that has come to the fore in the 2020 Companies and Advertisers Act. It's the idea really is to ensure or try to ensure that companies can meet their obligations, not necessarily to go into liquidation or receivership in doing so. And one of the main things about this is that the directors remain and management remain in control, or you have nominees and supervisors who sort of watch over. It's less stringent, less formal than what we had many years ago, which was the norm in our laws in Nigeria. I don't know how many of you are old enough to be practicing when we were in the 90s, early 90s, when we had schemes of arrangements. And that was, when we had all the financial crisis. But this is a new, well, not new, but a procedure where we're able to actually work the company through. So we have two distinguished speakers with us who have been clearly in practice of it for quite a while. I'm sure that they will disseminate a lot of information to us. I ask one of us to get your pen and paper, or those who use the iPad or whatever it is, to get theirs ready to take notes. We're going to allow them to speak, and then we'll be able to ask questions. So I ask that please, if you have questions to put to them, or things you want us to discuss, write them down, and when we get to that point, we'll just call on you. So I'd like to, on that note, first of all, say a big thank you to Mr. Ayodele Kusamoto, who's the chair of the committee, and also Dr. Adefulu, who's also with us here. So over to you, Dr. Peter Walton. We're happy to have you with us. I'm sure you can give a brief introduction before you go into your discussion, as well as Chris Umfreville, who I gathered a few minutes ago also worked with Dr. Peter Walton. So we have two for the price of one, I guess. Thank you very much. Over to you.
Thank you very much. I'd hesitate to introduce Chris sufficiently to show his prowess in this area, but very briefly, Chris and I have worked together at the same university for a number of years, though Chris has moved on to bigger and greater things elsewhere. And one of the things that we've worked on over the years, we sort of did some work for the government on pre-pack administration, and more recently we've done some work for the profession in the UK on looking at CVA. So really what we're basing our talk on today is some of the results of our research on CVAs. If you want to know more about us, you can Google us, and there's all sorts of stuff online, mostly positive, I think. What we're going to talk about is CVAs, and the way we're going to do this is I'll just talk a bit generally about how CVAs operate. So there might be people on the call today who are perhaps not as familiar with CVAs as they might be. And we're very happy to take any questions on any of the mechanics on how CVAs work in the UK. We're aware that the calmer version of CVAs has much in common with ours, so that it might be that there are some lessons that can be learned there. So I'll talk a bit about the mechanics of CVAs, and then Chris will talk a bit more in detail as to some of the findings from our recent research report, and then sort of tie it up with some strengths and weaknesses of CVAs, and then I'll return at the end to sort of wrap it up with in terms of how we see the future going. So Chris, did you want to say anything to introduce yourself before I start talking?
Thanks very much, Pete. It's a pleasure to be here with everyone today, and thank you for the invitation to speak. I think as we mentioned just before we started, and I know quite a few people have joined since, that there's so much we could say about this topic, and we've only got a limited amount of time. So we'd welcome questions relating to both what we're talking to and then any other issues that any queries you might have outside of that. And if we can answer them, we're happy to try and discuss them. But obviously we're going to pick out some headline points, and with a view to saying what makes a successful CVA, possibly looking at it from the sense of, well, what do we know perhaps undermines a CVA, and therefore what can we try and avoid to try and allow the statutory framework to achieve its aims.
Okay, Chris, well, we ought to get going on it really. So next slide, please, Chris. Just in terms of some general points about CVAs, if you're looking for the legislation in the UK, slightly mysteriously, part 1 of our Insolvency Act has got all the stuff on CVAs, but in terms of our insolvency rules, it's actually part 2, sort of time things move on. If you're interested in our secondary legislation or primary legislation, which is similar to yours, you could have a look at that. One of the points about CVA is, although it's designed to rescue a company, sometimes it's actually used in a slightly different context, and we've come across a number of cases where it's been used as a form of wind down of the company's business, but essentially that's not its main purpose. It is designed to rescue a company as a going concern, and the vast majority of CVAs, that's what's being attempted. It has to be in the form of either a scheme of arrangement or a composition of debts. Nothing too much turns upon that, but a composition of debts is the usual sort of form, so that you've promised your creditor a percentage of their overall debt in final settlement of their debt. Sometimes that's combined with a form of an arrangement where you have an instalment plan over a period of years or whatever. Sometimes it's in the form of a debt equity swap or something like that, but there has to be some form of arrangement with your creditors, and that may or may not take the form of a composition of debts. Otherwise, it doesn't qualify as a CVA. Importantly, it's a debtor in possession provision. So the whole idea is here that the directors stay in control, and so the directors are still very much in control of the company's business. So although they've reached hopefully an agreement with their creditors, the directors are still in charge of the business being run by the company. They're still in charge, they're still in play. They're the debtor in possession. They still owe the duties that they would normally owe in that circumstance. And so any supervisor of the CVA shouldn't be getting involved in the day-to-day running of the business. That's still the role of the directors. The other sort of main introductory characteristic is that it's an out-of-court process. So you shouldn't be sort of trundling off to court to get court orders asking for permission to do things too often. You really should only be going to court if there's a problem with your CVA in one form or another. So if you followed the procedure through correctly, certainly in the UK, it would be unusual for the court to get involved. So it's very much an out-of-court process, and that does allow for costs to be kept down, generally speaking. Next slide, please, Chris. So the way in which it works in the UK is usually that the directors of the company put forward a proposal for the CVA, and the statute talks about them then taking that proposal to a nominee who then issues a report on the proposal. And so this report is filed at court, even though there's no sort of court hearing to discuss the report. Interestingly, in practice, what tends to happen is, although the statute says the directors make the proposal and hand it over to the nominee, who then gives their opinion on whether or not the proposal is a goer or not, whether or not there's a reasonable prospect of it being approved and implemented, in reality, the nominee normally assists with the drafting of the proposal, and you normally need the professional assistance of an insolvency practitioner to actually draft an effective CVA. So it's quite often the nominee is involved in negotiating with creditors and involved in the preparation of the proposal. And even though it's provided in the name of the directors, so it's the directors who are putting forward that to the nominee, normally the nominee will have had some involvement in that. Importantly, the nominee has to be a licensed insolvency practitioner, so they're subject to all of their normal professional ethical controls that licensed insolvency practitioners are. If the report filed at the court is a positive report, so if it says, yes, this is definitely feasible, then you file that report at the court. The court doesn't discuss it, doesn't consider it unless there's some sort of problem later on. So the report is filed, and then the nominee just proceeds to call meetings of the members and seeks a decision from the creditors to approve the proposal. So it all happens out of court. Next slide, please. The way in which members approve it, so the shareholders just pass an ordinary resolution, assuming that they do approve it. With regard to the creditors' vote, importantly, it's only the unsecured creditors who get a vote, and the unsecured creditors need to approve it by a majority of 75% in value. So there's no class meetings there, it's just sort of one class, it's all the unsecured creditors together. So if you're familiar with the sort of scheme of arrangement case law on different sort of class structures and who goes into which class of creditors, there's none of that. You just got the one decision, and it's all the unsecured creditors together voting. There are some controls in the legislation to stop connected creditors sort of pushing through a proposal contrary to the wishes of unconnected creditors. So if the resolution is passed, it will be invalid if those voting against include more than half in value of the creditors who are not connected with the company, so external creditors. So that's a sort of a safeguard. A couple of other sort of important points, which we'll probably come back to as we go through some of the discussion that Chris will lead on. Secured creditors aren't bound unless they agree. So what that tends to mean in practice is secured creditors probably don't really, they don't sort of say anything really, they just sort of sit in the background. So they tend to let a CVA to go through. And if the CVA looks like it's in trouble, or if there are some problems later on, the secured creditor may or may not take steps to enforce their security, but they're usually happy to sort of sit in the background. As long as their security is still reasonably sound, they're not usually that keen to get involved in a CVA, but it will depend upon the circumstances. Perhaps more significantly, we've got preferential creditors, usually sort of employees to some extent, but it's really the tax authorities in our country who are the big preferential creditors. And importantly, a CVA can't be approved if it doesn't recognise the priority of preferential creditors. And what that means in practice is the tax authorities usually have to be promised 100% of any outstanding tax liability before the CVA can get over the line in terms of it being approved. So it can't be approved if the priority of the press isn't recognised by its terms. Next slide, please, Chris. If it's approved by the creditors and members, even if it's not approved by the members, the creditors' approval is enough for it to be approved and to be effective. If it's approved, it binds all unsecured creditors, so it takes a form of statutory contract in that sense. And the nominee usually is the same person who becomes the supervisor. It can be somebody else, but it tends to be the same person. Both nominees and supervisors are officers of the court, so they're under the control of the court. And although our case law has held that they don't owe private law duties, so they can't be sued for negligence, for instance, or for breach of fiduciary duty or whatever, they are under the control of the court and are subject to various controls in the Act and the rules. So there is obviously professional conduct rules as well would apply to them. So they're still reasonably well regulated, even though private law duties don't apply to them. Next slide, please. Importantly, if there are creditors who aren't happy with the approval of the CVA, creditors and indeed members can also apply, but creditors can apply within 28 days of it being approved. on the grounds that it's either unfairly prejudicial, there was some material irregularity in relation to the procedure. So unfair prejudice here normally means that the creditors are getting less, or some creditors are getting less under the terms of the CVA than other creditors. So there's differential treatment from one unsecured creditor to another, or that an unsecured creditor is getting less under the CVA than they would do in a liquidation. And so that's almost certainly going to be unfairly prejudicial, because obviously if you get more in a liquidation, why is the CVA such a good idea? It's going to be unfairly prejudicial to creditors, usually to receive less than they would have done in a liquidation. Material irregularity just really refers to, as its name suggests, some sort of procedural problem. It might be that some debts were accepted as valid debts when they weren't valid debts, that sort of thing, or votes were poorly counted or whatever. It's given effect as a form of statutory contract, and it can be an assets-based CVA, so the company could just sort of sell its assets and use the proceeds to pay off a percentage of the debt that it's owed, and it's done quite quickly. But a trading CVA is more common, certainly in the UK, and a trading CVA is where you have a period of time, a number of years, and the company tries to trade on and make monthly payments to the supervisor, who will act as a sort of payments handler to distribute those payments to the creditors under the terms of the CVA, and will also receive obviously claims and adjudicate on any claims from the creditors. And if things go swimmingly well, and everybody gets paid what they were promised under the CVA, then the CVA is deemed to be compliant and a great success. So that's a quick run through as to what a CVA looks like. I think I'm handing over to you now, Chris, to talk a bit more about how it's gone in the UK.
Brilliant. Thanks for that really helpful overview, Pete. So having considered the purpose of the CVA and the statutory mechanics of their operation, as well as the case law interpretation of that operation in the first few slides, I think before we go on to consider the outcomes of the CVA process, it's important for us to consider how prevalent its use is, and then we can go and consider what outcomes it leads to. I think the first thing to recognise is that the CVA is a really important and flexible rescue tool, much as the provision introduced in your CAMA legislation is as well. However, it isn't used that frequently. So the most recent statistical return from the Insolvency Service is on the screen right now, and you see three lines there. A creditor's voluntary liquidation is the blue line. Obviously, that's the most prevalent process of all. Administration, which is one of our key rescue processes, is the red line. You can see that sort of dropping down below sort of 2,000, operating around sort of the 1,200 to 1,500 mark over the last few years. And then CVA is represented by the green line right at the bottom. And although not shown on this chart, so as not to confuse things, compulsory liquidation is the second most common insolvency process in the UK, save for during 2020 and 2021 when the COVID restrictions against winding up petitions were introduced, so we saw a real drop off. But now those have been repealed, we're seeing an increase again, and that's the second most common process once again. So if we zoom in on the use of CVAs in administration, so we saw that the use of both processes has been on the decline over the last decade. But if we zoom in, we can see that is a bit more pronounced. So there's been a bit of an upkick in administrations in the last 12 months. Again, a knock-on effect of the effects of COVID and the statutory protections that were introduced to protect businesses during that period of uncertainty. But if we focus on CVAs now, we see over the past decade, we've seen a decline from 829 CVAs commencing in 2012 to just 111 commencing in 2022. So there's a steady reduction in that. It's interesting to note that in the latest data return of the Insolvency Service, the commentary reported that the number of CVAs in 2022 was 3% lower than in 2021, 68% lower than 2019, and the lowest since 1993, which, bear in mind, this procedure was first introduced in 1986. That really is quite a low figure. So in the context of how often the CVA is used, we're now going to go on to consider what CVAs actually achieve in practice, and perhaps identify some of the reasons for its decline, but also identify some of the strengths of the process as well. So there is limited published data on the use and outcomes of CVAs. So as the data I've just shown indicates, we can see how many CVAs are commenced every year, but it's difficult to then follow through and understand what those CVAs are leading through to. The most recent report is one that Pete and I worked on together with our colleague, Dr. Lizelle Jacobs. It was published in 2018, working with R3, our trade body for insolvency professionals in the UK, and the Institute of Chartered Accountants for England and Wales, and that is company voluntary arrangements evaluating success and failure. There's a QR code on the page as well, so if anyone is interested in having a look at that report, you can scan the QR code. I'll for once justify wittering on for a little bit so that you have time to do that, but if you would like to access it, as Pete said earlier on, you can just Google it, or for ease, you can download it directly via the QR link. An apology for the ICAEW in talking about this, in that I've had to cover up their logo and put in that QR code on the slide. So better get that apology out there while we're talking. So a quick overview of the project before we look at the findings. We looked at the outcome of all 552 CVAs which were commenced in England and Wales in the year 2013 through a longitudinal study. Essentially, we looked at them through to November 2017 to see what outcomes were achieved. The study revealed that 93% of the companies that were using CVAs in that year were classed as either small or micro. So this is dominated by the smaller end of the scale for organisations in the UK. And the CVAs were used by companies across a broad range of industries. It was dominated by construction, food and drink services, support services and retail, but there was a wide spread of all industries represented. Interestingly, and anyone who's followed CVAs in the UK over the last few years will notice that there's been a lot of press coverage around use of CVAs to compromise landlord rights and looking at leasehold portfolios for retail companies. This year we didn't actually see any major retailers, so the issues that have been raised in that space didn't come out in this report. Though there was a recent report published last year by the Insolvency Service that looked specifically at landlord issues, if anyone wanted to look at that in more detail. So then, what did our research find? Well, the report was called Evaluating Success or Failure, and when considering success or failure, a good starting point is going to be looking at the outcomes of the procedures. And as Pete said, the starting point is if the CVA does what it said it was going to do, then it's fully implemented, and you would say that was a success. Of the data, of the 552 CVAs we considered, we found that at the end of the survey period, only a sixth of them were implemented, i.e. that they had been completed in accordance with the original plan, or in some instances, a revised plan. So during the course of the CVA, some revisions were put through and those were then adhered to. A further, around a sixth were still ongoing, which means that around sort of 4.5 years after they were commenced, they were still running through at the end of the survey period. But perhaps somewhat shockingly, 2/3 of the CVAs were terminated. And by that I mean they didn't complete in accordance with the original plan. So it looks a bit like a sixth were fully implemented, a sixth were ongoing, which they kept going for over 4 years. That looks encouraging, but 2/3 were terminating early. So it doesn't look great for the CVA, but is it really as black and white as this? So the aim of the CVA, as Pete indicated, is to rescue the company as a going concern. But if we look more closely at the implementation figures, we see that this isn't necessarily what is actually achieved. So of those sixth of CVAs which were fully implemented and therefore look like successes, if we look a bit closer, we see that 20% of those implemented CVAs led to an immediate follow-on insolvency. And this really points to the fact that Pete referred to at the beginning of the presentation, that actually the CVA has been used to almost lead to a director-led winding up to collect and distribute the assets with less expense than you might see in a traditional liquidation. So a number of these CVAs were then going into liquidation or perhaps strike-off. A further 13% entered another insolvency process during the survey period. So when we followed the data through, whilst the company came out of the CVA, resumed trading trading, at some point before the end of the survey period, they then entered into a subsequent insolvency process that wasn't a second CVA. So what we see is that only actually 2/3 of the implemented CVAs actually saw the company survive. So just over 12% of all of the CVAs sampled. So what that highlights is that implementation doesn't necessarily mean success if we're to consider success being the survival of the company. That doesn't mean that CVAs don't achieve more positive outcomes. And what I mean to say there is, could positive outcomes be achieved even when a CVA isn't implemented but terminates early? Now, the headline figure was no, because it hasn't achieved its aims. But could it have achieved something else that's positive? So let's have a think about what happens when CVAs terminate. The chart here shows the length of the CVAs, the blue line demonstrating when the CVAs were fully implemented, so the number of quarters that it took for implementation of the CVA. And you see a fairly steady route there all the way through to around 4.5 years or so. And the red line indicates when CVAs were terminated early. We see that the vast majority of CVAs that terminate early do so within 2 years of the CVA commencing, with peaks at 6 months and then again between 12 and 18 months. After this 18-month period, we still see CVAs being terminated early, but the rate declines. The question, therefore, is what's happening during this period that leads up to the termination of the CVA? As Pete mentioned earlier on, the majority of CVAs tend to be trading based. What that means is that the compromise that's reached with the creditors is essentially paid for by the trading receipts of the company as it carries on its business under the remit of the CVA. So as it trades, a bit of money is put aside every month to go into a pot to pay back the creditors, either during the period or in a lump sum at the end, depending on the terms of the CVA. And the company will be making contributions at varying rates. So some may make a constant flat rate, some may have increasing payments over time, balloon payments, bullet payments, etc. So it can be structured with real flexibility. But essentially, most typically, contributions will be put into the pot through the duration of the CVA. Therefore, you can make an assumption that the longer the CVA runs for, the greater the pot that's accrued, and therefore the greater a chance of distribution to the creditors. But is that how it works in practice? So can we see that termination could equal success? Well, the data's a little patchy here, and the sample size reduces dramatically in the later periods as well. So we can't sort of stick too much to the data, but we do see some interesting patterns here. And there's a lot of discussion of this in the report that I provided the link to earlier. This is just one of the charts, which is a little bit complex, but if we drill down into it, it shows some interesting data. So on the x-axis, what we're showing is how close the CVA gets to its target completion date. So if the CVA said at the outset it would run for 36 months and it terminated after 18 months, it would go 50% of the way towards its target completion date. Equally, if it said it would run for 4 years and it terminated after 24 months, then it would have got 50% as well. So it's the relative length of the CVA. The y-axis then shows how close the dividend paid out is to that was promised. So if 100p in the pound was promised, so a full repayment, how much was actually paid? So if they paid 80p in the pound, that would hit 80% of the promised dividend. So it's relative to, basically we're looking at what was achieved relative to what was promised. And we can see on the scatter plot a slight trend to the fact that the nearer the CVA gets to completion of its proposed term, the closer the dividend payment is to what was offered. Although it's important to recognise that all cases really are falling some way short. So whilst the creditors aren't receiving what they expected and they signed up for under the terms of the statutory contract that is the CVA, we see that the longer the CVA runs for, the better chance there is that the creditors receive a higher payout. Now we contrast that with what they may have received if the company had gone through either a pre-pack administration or gone straight into liquidation. It's likely a much better position. The recent research that I referred to of the Insolvency Service looking at the impact of landlords said that of the 59 CVA proposals reviewed in that research, the estimated return in a liquidation was between 0 and 3%, so maximum of 3p in the pound. So we're seeing that CVA running for a period of time is much better for those creditors. Additionally, we also see the CVA as being an opportunity to soften the blow of a major creditor going into insolvency. You have the opportunity to reduce your exposure to the creditor, to repivot your business. So if you're exposed in a big way to a particular creditor, you can look to diversify your business and your revenue streams, or potentially reorganize the business going forward, as well as minimizing the impact of its insolvency. Okay. And one of the problems we identify with the CVA is that there's no automatic moratorium. And as such, the company is exposed and vulnerable during the key negotiation phase. The company, in proposing the CVA to its creditors, needs to make them aware of its financial problems. But then it's put them on alert, and there's nothing it can do to stop them taking self-help and undermining the CVA. For example, if a landlord decides to terminate a lease on the basis of the tenant's insolvency, then the tenant will have a significant impact on being able to continue its business. At the time which conducted the survey, there were two types of moratorium that companies could access: the Schedule A1 small company moratorium and the Schedule B1 administration moratorium. The data, however, shows that these are little used, just 19 in total, 15 of which were used by small companies. This despite the fact that we said that 93% of the 552 companies were small companies. So the vast majority could have made use of this Schedule A1 moratorium, but they just weren't. Now, the sample is too small to draw a firm conclusion from, but it does suggest that the combination of organising a CVA with the benefit of a moratorium before agreement does produce better outcomes. We see a 42% implementation rate as against the 18% in the standard survey. We see that 37% of companies see the CVA implemented and then go on to survive versus 12.5% in the standard survey. We see a huge reduction in the number of early terminations, 65 in the main survey down to 21% of CVAs making use of some form of moratorium. So what does this data tell us? Well, it tells us that the CVA is valuable, but it's not perfect, and it can help facilitate both company rescue and enhance returns to creditors. And as such, it has both strengths and weaknesses. So if we think back to the mechanics that Pete described earlier, and we look at some of the data that we've just gone through, we can see that the strengths of the CVA include the fact that it ensures that a minority of unsecured creditors can't block a company rescue. So if 3/4 of the unsecured creditors by value want to see this achieved and they're happy with the outcome, even though they don't get what they were expecting originally, it can go ahead. We see that you have a nominee who is an independent intermediary negotiating terms between creditors and the company, someone coming in and really supporting that process. Because it's an out-of-court process and a debtor in possession, with the nominee being slightly hands-off compared to all other forms of insolvency process, the costs are kept relatively low. And developments since our report are that R3, who sponsored the research, have created some standard terms and conditions for CVAs to better facilitate CVAs being entered into and keep those costs down. As Pete said, although the legislation says that the directors propose the CVA, it will typically be drafted by a professional, and obviously there's going to be a cost associated with that. Also, we've seen the introduction of legislation that prevents against the termination of supply contracts once a company goes into an insolvency process. That means that if a company goes into a CVA, it prevents suppliers from terminating the contract or significantly changing the terms, which could undermine the viability of the CVA and wouldn't necessarily have been foreseen when the CVA was proposed. There are, however, weaknesses though. The ostensible success rate isn't particularly high. Whichever way you cut it and try and say, well, the longer it goes on for, even it terminates, there's some success, it's still not achieving what it's setting out to. There has been some uncertainty about the role of the nominee and their independence. There's an observation that the directors almost seem to think that someone's going to come in and hold their hand through the process, whereas actually it's a bit more of a hands-off process. There's a bit of a limbo period. So when the CVA goes through, creditors have 28 days to object via an application to the court. And that leaves a bit of a limbo as to whether or not the CVA is going to actually be successful. We've seen there's questions about the use of a moratorium and its availability, although that has changed with some recent reforms that Pete's going to talk through shortly. One of the big issues is that the typical length of a CVA being proposed is 5 years. We also found the average age of a company using a CVA was typically around 3 years. So a company had found itself in such financial difficulty that after 3 years it needed to look for statutory protection. And it was making promises for a period longer than it had been in existence up to that point. So it's never really going to work. We also saw the impact of the role of HMRC. So with many smaller companies, HMRC was often the major creditor, so could make or break a CVA. So its requirements drove the terms of the CVA, and sometimes they might be unrealistic and ultimately lead to its demise. Since our report, we've seen the reintroduction of the Crown Preference, which has boosted HMRC's ranking and therefore potentially undermines the viability of CVA, because as Pete said, you have to take into account the priority to those preferential claims, and therefore there has to be a lot more money in the pot to pay off HMRC, which was historically one of the major unsecured creditors. So I'm going to hand back over to Pete now, who's going to talk you through some reforms and some opportunities for the future.
Thank you, Chris. That was excellent. Really enjoyed that. The thing that's happened in the UK in recent times, during COVID, really, we had a thing called Corporate Insolvency and Governance 2020, and although that was partly a reaction to the pandemic, it also taken as the opportunity to bring in some stuff the government has been toying with for a while, and so we've got two new procedures which are sort of part of our framework now, so they're probably worth mentioning. So the first one is we've got a new standalone moratorium. So the old Schedule A1 moratorium that was specific to CVA has been abolished, and we've got a new standalone moratorium, and that is potentially more popular. It's a 20 business day moratorium, but it can be extended and has been extended. And the idea is that it allows a company a breathing space to put forward some plan to protect its chance of survival. I've recently just finished with my colleague Liz Jacob at Wolverhampton. We've just done an evaluation of the Act for the government, and one of the things that we came across was that the moratorium was being used quite as a precursor to CVAs. So it was quite popular with people who had used it in giving the company a bit of time to get its act together, to get a decent CVA across the line. One of the things that Chris pointed out was that where a moratorium had been used in our sample, when we looked at CVAs, it tended to lead to a better result because the CVA had a bit more time to be negotiated, drafted. And so there is a suggestion that our new standalone moratorium is likely to be a benefit to assisting CVAs getting over the line. One of the problems is some of the terms of the moratorium, because it's all been drafted afresh, some of the terms are a bit vague, and so we're hoping later in this year that the government's able to sort of sort out some of the teething problems with the drafting of that. The other thing that people get quite excited about in the UK, we've got a thing called a restructuring plan. And so we've got this new procedure, a restructuring plan, which is very much based upon the Companies Act scheme of arrangement. There was mention of that at the beginning, that you've got a form of scheme of arrangement which possibly isn't terribly popular. And our scheme of arrangement has still been used quite frequently by companies in financial distress. But the problem with a scheme of arrangement is that you've got to get every class of creditor to approve the scheme. It's long and expensive in terms of a procedural thing to follow. The restructuring plan is essentially the same procedure. You still need a convening hearing at the court, you still need a sanctions hearing at the court. But the big difference with a restructuring plan is that if you've got a class creditor who votes against the plan, the court at the sanction stage can cram down that class of creditor. So we've sort of stolen that probably from sort of Chapter 11 US stuff. So if you've got a class of creditor, as long as they're not going to be worse off under the plan they would be in the relevant alternative, particularly a straight liquidation, then the court can exercise its power to cram down, so force the restructuring plan on the dissenting class of creditors. So again, the restructuring plan is proving to be relatively popular, but we're not talking about lots and lots. Still a relatively small handful of cases, a bit more than a handful, but not much more than a handful, mainly because it's quite expensive and quite time consuming. Next and last slide, please. Thank you. So what's the future for CVA? Well, we've obviously no idea. We reviewed these reports and we know what we can see the future start. So the restructuring plan is being seen as a big alternative to companies, even in the SME sector. But it has to really be larger SMEs to use the restructuring plan as opposed to the CVA because of the time it takes using it. I think one of the biggest competitors in the UK for a CVA is a pre-pack administration. It's still a lot quicker and easier and cheaper to pre-pack a business than it is to spend years trying to pay off your debts in a sort of potentially more responsible fashion under a CVA. So pre-packs seem to be as common as ever at the moment, whereas CVAs are currently on the wane. And it's partly because we're coming out of the pandemic and people just, I think, don't have the energy to try and rescue their companies as going concern. And so they're just sort of pre-packing the business, either back to the existing management team or the next person. But the real killer for CVAs in terms of getting them approved is because our tax authority, HMRC, is now a preferential creditor again, having not been one since 2003. They can pretty much demand 100% payment for a CVA, otherwise the CVA can't be approved. And the fact that you can no longer sensibly negotiate the tax liabilities down to 100% payment means the CVA isn't always going to work for a company that's got itself into financial difficulties. Quite often, tax liabilities are the biggest liability that the company's got. So the reintroduction of the Crown preference hasn't done it any favours. So we've got an opportunity heading there. So the moratorium, we think, is potentially a real winner, and it does give you time to put forward a CVA. So we think that's a positive thing. In terms of further reform, the sort of things that we were recommending in our report, some of them have been given effect to. So I think the biggest problem really is quite often our tax authority insists upon a 5-year term for a CVA, for a trading CVA, and that's just too long. So we think you shouldn't be looking at more than 3 years for a trading CVA. Otherwise, you're just sort of signing up to fail almost. One of the things we've always been very keen on, it's something that's a thing around the world really, is better education of directors, so that directors can see that they get themselves into financial difficulty earlier and take advice earlier, and maybe start to plan for a CVA earlier. That would hopefully lead to a better result for all the creditors. One of the things that has happened in our jurisdiction is that the statements of insolvency practice have been amended following our report to make it very clear what the supervisor does and what the directors do. So the point that Chris made, the supervisor isn't there to run the business. The directors are still there to be that supervises the CVA. If you need help, you need a company doctor to help you change your business plan or whatever, that shouldn't be the supervisor's role, and that should be somebody else's role. And the other thing we think is a problem with CVAs in a sort of publicity way, really, is that the filings that our companies have don't really tell the whole story. So we would like to see filings explain very clearly what was promised in a CVA and what actually happened ultimately. So even if you didn't get full payment that was promised in the CVA, if it can be shown that you got more under the CVA than you would have done in a liquidation, it's still seen as a real positive thing for creditors. There's more, there's more to be said for the CVA than just sort of yes or no. Has it been a success or has it been a failure? Has it been implemented or been terminated? Isn't the whole story. So that's our sort of further on. One thing that Chris mentioned was that R3 have produced some standard terms and conditions. I should declare that I was involved in drafting those, and they're freely available on R3's website. So if you're not quite sure what a CVA might look like, if you can go onto R3's website, and the sort of examples of a CVA and the standard terms and conditions are freely available for people to adapt and use as they wish. So you might find that's some use. Thank you very much. I think we've finished.
Thank you very much. I'm sure the participants have learned as much as I have. I must say we're lucky to have that insight. As I said at the beginning, the CVA is relatively new under our new Companies Act. I'm very fortunate to be one of my colleagues here. To have been, I think, the first supervisors nominees under that law. We're very lucky that we had a test ground because all the creditors there were actually members of the company. So it was easy to, but I'm imagining from what you said, when we begin to have CVAs where there are multiple creditors and diverse creditors and diverse interests, what it would look like. And one thing that springs to my mind is one thing that Chris said, that as far back as the committee reports, I remember when I was doing my master's that I was focused on that. I used that as a real issue because we had problems in Nigeria with the finance companies. And we had all the schemes of arrangement, and you had to go to court, and it cost a lot of money. That we need to have a situation where we can have the creditors come together and say, you know what, let's give them time to trade out of this and pay us over time. So that was very welcome. But the problem I had then and I still have today, is the issue of moratorium. If a creditor is still able to scuttle basically the whole CVA before it even starts, then it's a real tough task, especially where there's a jostle between creditors. To get there, they also get creditors, so I want to get there first and get as much as I can. And if I go to the CVA, I might not get what I expect. I don't know what you think. I've heard the outcome of the research on moratorium, but do you really think that the CVA has a chance of long-term survival, given that situation?
Chris, do you want to go for that, or shall I go for that?
Yeah, I'll have a go. I think the moratorium helps, but as we saw in our research, whilst the moratorium appears to lead to better outcomes, there were positive outcomes without the use of a moratorium. And depending on how you frame positive outcomes, you can see even those companies that didn't stay in CVA for a long period of time through to completion still led to positive outcomes. So I don't think we should worry about the lack of a moratorium preventing success, but the availability of a moratorium may improve success. I think one of the things we talked about was around education of directors, and I think that's really important as well. But I think as well, education of creditors is going to be important as well, because even in those CVAs that didn't achieve what they set out to, the creditors have done better, both in terms of the returns, pence in the pound of what they were owed, but also an opportunity to adjust. So a good example in the UK is when MG Rover went into administration in the mid-noughties, and the impact on the supply chain in the local area was huge, because you had companies whose 90% of their business was going into that one business that suddenly disappeared overnight almost. And had they had a sort of a soft landing, an opportunity to pivot their business to find other businesses, there wouldn't have been the knock-on insolvencies. So I think some creditor education as well as director education would try and help that. But obviously, if you can get a moratorium that would facilitate CVAs as well, all the better.
I would just add to that. That's absolutely true. The other thing is, it's important for the insolvency practitioner when acting as a nominee to be ostensibly independent and somebody who the creditors can trust, because what we tend to find is that in a lot of cases you don't need a formal moratorium, because the creditors trust the word of the IP that they're negotiating with. And so if your insolvency practitioner is able to convince the creditors to hold fire whilst the CVA is put to them, that's probably the best result. But obviously you're absolutely right, an informal agreement isn't the same as a sort of lock-up agreement, isn't the same as a formal moratorium. So that is a potential problem if you've got itchy creditors.
Yes, I'm just thinking, the culture-wise, it's a bit difficult for us here. I guess that's why the court processes have been more popular than the other ones. But I'll ask if anybody has any question that they'd like to put, or any comments they'd like to. Please raise your hand if you can, and let's proceed. We've got about 10 minutes thereabouts. Okay, while we wait for that, I also wanted to point out another thing. The issue of the process not really being a court process. Do you see the fact that the nominee supervisors are officers of the courts? Is that in any way a contradiction to your mind? Because you say, look, the whole idea is that we shouldn't really have to go to court, none of this. But if the person who's supervising is a court nominee, then it may sound like a contradiction. Before you answer, I just like to say that there's the question and answer box where people can put their questions. So please do if you have any questions. But please go ahead. What do you think?
I think the nominee and supervisor is a really interesting role because you don't have managerial control in the way that you do for a liquidator or a receiver or an administrator. Yep. And so I think it's probably one of those roles that does require some statutory framework to control, and that's what you'd have as your act and your rules. But I think the fact that you're also an officer of the court just gives extra flexibility, preventing the nominee or the supervisor sort of doing anything particularly outlandish or questionable. So it might be that you haven't done anything illegal, but if you've put forward a CVA that you know is taking advantage of certain creditors or whatever, it might be your professional body catches up with you, but I don't think it's a bad thing that you're an officer of the court, because you should be acting in a way which is appropriate to all comers. So I think being subject to the control of the court on top of that is an extra layer of confidence that the creditors can have in you.
Yeah, I agree. I think it builds on that point you were saying earlier about building confidence with the creditors as well.
That's the best we can do on that one, I'm afraid.
Well, I do have my hand up if I could ask a question.
Please go ahead.
Yes, thank you, Mr. Kilme. Chris and Peter, so you've talked about one of the questions that I think is important for the Nigerian audience. Someone has asked what it means when we say someone is an officer of the court. Does that mean disobeying the insolvency practitioner can be viewed as contempt of the court? Or could you unpack what the content of being an officer of the court entails? That's one. And the other question I think that is also arisen in the Nigerian context is when it is said that a matter is to be filed, or where the procedures talk about filing issues at the court. What does that really mean? Do you just go there, drop the documents and leave, or does that require a response from the courts?
Okay, well, the easier one is filing. You just deliver it to the court, however the court requires it to be filed. So we do a lot of online filing nowadays at court. So depending upon how your court wants you how the court wants to receive its documents, you might be able to do it all online. That's very common. But otherwise, you just send a trainee along. Well, you might not trust a trainee with the documents, but you just schlep along and file it and get a receipt from the court. So it is literally just depositing the documentation at the court. And so the point is, the court has then got a record of the proceeding. So even if nothing goes wrong or whatever, there's still a record of the proceedings at the court. The CVA will still need to be filed at Companies House, so there's a public record that people look at, but there's also a court record. And part of that moves into what sort of the first question about, and that's that your nominee and supervisor is under a duty to the court as well as to under the statutory restrictions. And so as an officer of the court, they need to be entirely transparent and fair in all their dealings with the court and with other people. And if they're not seen to be transparent and fair in all their dealings, the court can take direct action against them if a creditor complains about their behaviour. I don't know if you want to add to that, Chris.
I was going to, there's a question in the chat that sort of links to that around who's responsible for appointing the nominee or supervisor. I thought it might be a good opportunity to sort of pick those together in a sense of, as Pete said, typically the nominee will be put forward by the directors and they will work on the proposal, and then ultimately they are appointed through the approval process. So as Pete mentioned, the resolution of members and then the resolution of unsecured creditors as well. So if the creditors aren't happy with the proposed nominee, they could put forward someone else who would then have the opportunity to be appointed as the supervisor. That's what I was going to add.
Well, two things. Somebody asked a question. First of all, I'd like to just respond to Dr. Adebola. The things filed in court is usually done by ex parte summons, so it's just really for the record of the courts, and the court gives an order, and I think that just sort of strengthens the spine, so to speak, of the nominee. Someone asked a question about whether CVA is active in Nigeria. Is there restrictions on nature of business it can cover? CVAs are not really, like I said earlier, they're new. As far as I know, the one that was done by Okorie Kalu and I, the first one under this law, and I don't know if there's any other. I can't be categorical about that, but it's clearly not as popular as the liquidation or the receivership. And one of the reasons why I believe that the SBL has had this session is to enlighten us, educate us on the opportunity that we have in using the CVA to try and rescue the businesses. So I hope that answers the question. How are the major lessons Nigeria learned from the practice of CVAs in the UK, especially since CVA seems to be less favored in the UK? I think that somebody can answer that for us.
Yeah, should I take one, Pete?
Yes, please.
Please do.
I think essentially on the basis of what you said with you being at the beginning of the CVA journey in Nigeria, you've got an opportunity to almost learn from our mistakes and get it right, because a lot of it's around how things are structured, credit self-interest, and education of directors. So I think educating directors about how to use the process and the limitations of the process as well. Setting out realistic proposals, both in terms of how much can be repaid over what period. So it may seem a good idea to say, well, let's stretch the repayment period out, but there are restrictions on the company trading during that period. So, for example, you can't pay dividends to shareholders, you can't increase directors' salaries, etc. Now that becomes quite an oppressive environment to work in, especially when you could, in the UK, pre-pack instead. So I think learning from what doesn't work to make sure that you are realistic in how you structure these things would be a really good start. And as I said, director and creditor education would be really valuable as well.
Thank you.
I can ask a question, please.
Yes, please, Chairman.
So this is very much like, thank you very much for the presentation. It's been wonderful. This is very much from a selfish perspective now. What I always ask myself, what's in it for me? And a lot of people in this webinar are probably lawyers and asking themselves, well, fine, CVA, but what's in it for me as a lawyer? So can you, enlighten us and tell us what are the opportunities for a lawyer in this setup in which a CVA would be implemented?
Well, I guess like any work, there's always a fee attached to the advice you give. So in terms of drafting CVAs, what we tend to find in the UK is that although an insolvency practitioner will be involved in the drafting of the CVA, quite often the CVA is largely drafted by lawyers. So the documentation involved will have to have a lawyer involved. Similarly, when you are conducting any statutory process where there's a procedure, you would normally want to have a lawyer's input in making sure the statute's been followed accurately, ticked all the necessary boxes. So I think as a lawyer advising a company, as a lawyer advising a nominee or supervisor, there's quite a lot of opportunities to work with that and to suggest the CVA as an option to your insolvency practitioner clients, to your business clients.
I think as well, added to that, we said at the top of the session that one of the real benefits of the CVA is its inherent flexibility. Certainly the UK statute is very short. There is obviously guidance in the secondary legislation, but there's a lot of flexibility in how you operate a CVA. And again, there's opportunities to learn from our mistakes in terms of what works and doesn't work in our statutory framework. But I think it can be used to deliver a range of different outcomes for clients that, from the sounds of it, wouldn't be available under more restrictive traditional opportunities you have in your statutes.
Yeah, and I think if you've got a committed shareholding in a company that really want the company to survive, CVA is a really good option.
All right. Thank you very much, Chris and Paul. Thank you very much. I know there are many more questions. We could be here. It's such a noble area of law for us, or area of insolvency for us, that we ask questions over and over again. I'll implore the chairman of the section on business law, who's graciously attended with us here, Dr. Adefulu, and as well as the chairman of the committee itself, who just spoke, Sabo, to come back for you, so we can come and have further discussion on this. But it certainly has been enlightening, and I'm sure that there's been benefits to this. We'll take it further in Nigeria, I'm sure, and report back on how much lessons we've learned from your practice of the CVA, or your conduct of CVA in the UK. Thank you very much indeed. Very appreciated.
Thank you very much for having us. It's been great.
Thank you. And I noticed there are a few comments in the chat about some of the links we talked about, so I'm happy to share some of the links after the session so you can circulate to attendees.
Yes, I'm sure the SBL would disseminate that to us. Thank you very much.
Wonderful. Thank you very much.
Thank you.
Thanks. Goodbye.